So at this point in the year, we have talked about 13 of our 15 required court cases. That's very impressive. The only court cases we haven't addressed yet, at least thoroughly addressed yet, are Brown versus the Board of Education, which comes up in our next chapter next week, and Citizens United versus Federal Elections Commission, which will come up in a later unit when we get back from winter break. We've talked about the 13 remaining cases. In terms of tomorrow's assessment, the only cases that might appear are cases that are specifically dealing with civil liberties. So I'm not going to go back over every single one of our required court cases that we've talked about. I will very quickly go back over the required court cases that address civil liberties, since we're finishing up our civil liberties chapter. You have, or you had the option to have a graphic organizer that contains summaries of each of these cases. So I'm not going to move super quickly through each, but I'm going to give a pretty brief explanation of each under the assumption that you have this in your notes and you hopefully have your own summary in a graphic organizer. Okay, so our first required court case that deals with civil liberties is Schenck v. United States. That is a case that deals with freedom of expression, and it is the case that established the clear and present danger precedent. If your speech creates clear and present danger, it's punishable by the government. Schenck was distributing leaflets encouraging young men to resist the draft during wartime while there was an active draft taking place, and the Supreme Court agreed that his expression had created a clear and present danger, and so it was punishable by the government. Our next court case that deals with civil liberties is Engel v. Vitale, and that is the case that deals with the Establishment Clause and says that that school-sanctioned prayer would be a violation of your Establishment Clause protections. Fine. The way that I remember this one is Engel kind of looks like the word angel, so that's how I remind myself that this is a freedom of religion case, and it happens to be a Establishment Clause case specifically. Gideon v. Wainwright, that's a civil liberties case as well. It's, interestingly, the case that I think we've talked about the most this year because it acts as an example of so many things. Gideon v. Wainwright is a really good example of a Sixth Amendment right to an attorney and 14th Amendment due process rights case. It's a really good example of selective incorporation, which we will review in more depth in just a moment. But this is the case that uses the language of the 14th Amendment to apply your Sixth Amendment right to an attorney to the states. And it's a good example of a case that was heard in forma pauperis. Tinker versus Des Moines, Iowa, that is a freedom of expression case and specifically a case regarding symbolic speech. These school children wanted to wear black armbands to school to protest the Vietnam War. They were told that they couldn't, and the Supreme Court said that the wearing of black armbands to school is a protected form of symbolic speech. And we'll talk even more about symbolic speech when we get to our review. So Tinker versus Des Moines is a really good example of a freedom of expression case, a symbolic speech case specifically. It's also a really good example of a case dealing with the rights of young people. Students do not shed their constitutional rights at the schoolhouse gate. But it also reminds us that schools can regulate expression if that expression is impeding the educational process. So if a school can argue that a form of expression is detrimental to the educational environment of the school, then the schools do have leeway in regulating that expression. New York Times v. United States, another First Amendment case, this time freedom of the press. The New York Times wanted to publish information that did not make the United States look very good regarding the war in Vietnam. And the Supreme Court said that the New York Times has the constitutional right to publish that information. Wisconsin v. Yoder, that is another First Amendment freedom of religion case. This case specifically deals with the free exercise clause. There was an Amish community that did not want to send their children to school past the 8th grade, and that was contrary to the Wisconsin school attendance laws. And the Supreme Court put those two things on a scale. The Amish free exercise right to not send their kids to school in line with their religious beliefs versus Wisconsin's compulsory school attendance laws, and the free exercise clause writes one out here. Roe v. Wade came up in our discussion of civil liberties. Roe v. Wade is the Supreme Court case where the earlier precedent of privacy was applied to the abortion issue. And then lastly, in terms of civil liberties cases, we have McDonald v. Chicago. McDonald v. Chicago is the Supreme Court case that selectively incorporates the Second Amendment to the states. So questions about these required court cases. And every concept that I just brought up is going to be readdressed when we get to the content review, but any questions about the court cases specifically? Okay. All right, then here it is. This is our big review slide. This is all the stuff that the College Board wanted us to learn from chapter 8, our chapter on civil liberties. I'm going to talk about some of these concepts in more depth and for a longer period of time than others. But there's always a method to my madness. I created tomorrow's assessment. I've very recently, as of this morning, gone back over tomorrow's assessment. So if I spend more time on certain concepts than others, there's thought behind that. So rest assured. I also want to point out that at the very end of our review, we're going to address some content from previous units. We are halfway through the school year, pretty much. We've already finished Unit 2, which comprises about 33% of this class's content. So we are well into the class in a way that makes previous content fair game on upcoming assignments and assessments. It's almost impossible at this point in the year to find, especially FRQs, that do not require you to draw on previous concepts. So that is absolutely true of tomorrow's FRQs. You only have to do one, but I have two as options tomorrow. Not options for you, options for me to pick for you. Both of them require content from previous units. So I want to make sure that we're brushing up on that, or at least addressing it. All right, so this chapter was all about civil liberties, and civil liberties are some of our most fundamental rights and freedoms. In the US, political culture dictates that we feel we're born with these freedoms. And then the government has to then respect them. So things like freedom of the press, freedom to protest, protection from unlawful searches and seizures, the right to a jury trial. These are all examples of what we would call civil liberties, and they're all examples of fundamental rights that we feel we're born with in the US. Much of the Bill of Rights, and I know I skipped that, I'll come back to it in a second, much of the Bill of Rights was created to ensure that the government is protecting those civil liberties, is protecting those freedoms. We started out this chapter talking about the Bill of Rights because of that, because so many of our fundamental rights are protected by the Bill of Rights. At the Constitutional Convention, the creation of a Bill of Rights was a bit controversial. And the agreement that was struck is that the Constitution, as a preamble and 7 articles, would be ratified, and then a Bill of Rights would be added after the fact through the amendment process. And that explains why the first 10 amendments to the Constitution are collectively known as the Bill of Rights. And we've really been working our way through those 10 amendments all throughout this chapter. I skipped over civil rights because we're going to spend our entire next chapter, all of next week, talking about civil rights. Civil rights basically means that the law should apply to us without unconstitutional differences. Notice that does give some space for the law to apply to us differently. The most classic example of this is men have to register for the draft, women do not, and that's not considered currently by the courts a civil rights violation. But the laws should apply to us without unconstitutional differences. That's the basic, that's kind of the building blocks of civil rights. We'll talk about that next week. Okay. In order to understand how our civil liberties impact our relationship with national, local, state government, we need to understand the concept of selective incorporation. So what is selective incorporation? We've spent quite a bit of time talking about it this year because I really wanted us to understand not just its definition, but where it stems from and then the impact that it's ended up having. We talked about US perspective prior to selective incorporation. We talked about why there's this relatively new belief in selective incorporation. What is it? Okay, I'll shout it into the universe and into here. So selective incorporation is using the language of the 14th Amendment to apply provisions of the Bill of Rights to the states. When the Supreme Court uses the language of the 14th Amendment to apply provisions of the Bill of Rights to the states. Selective incorporation stems from the language of the 14th Amendment. Because the 14th Amendment says things like, no state shall infringe upon your due process rights. No state shall infringe upon your equal protection rights. So after the ratification of the 14th Amendment, the Supreme Court began interpreting the Bill of Rights differently and really interpreting state actions differently. And in many cases, the Supreme Court handed down rulings applying provisions of the Bill of Rights to the states and saying that the Bill of Rights does not just protect you from actions of the national government, but the Bill of Rights also has the potential to protect you from actions of state and local government. Gideon v. Wainwright is a good example of a selective incorporation case. Gideon felt that Florida had violated his Sixth Amendment rights to an attorney, and the Supreme Court agreed with him that Florida should have provided him with an attorney because the Supreme Court said that the 14th Amendment, no state shall deprive you of your due process rights, selectively incorporates your Sixth Amendment right to an attorney to the states. I won't put you on the spot right now because I am recording this review, but if selective incorporation is one of those concepts that at this point in the year you're still having trouble wrapping your head around, let's arrange a different time after class today, tomorrow morning, when we get back from winter break, whatever. But if that's a concept that you're still really struggling to understand, let's definitely make sure that we arrange a time to hash that out together. Doesn't have to be right this second, but it should be soon. Okay. Tomorrow on your multiple choice portion, there's a question that is going to ask you to match constitutional clauses with their basic explanation. And I'm never trying to trick you or make things difficult. These are the constitutional clauses that will appear on that section, and we're going to go over a basic explanation of each of them today. Here's how simple some of this will be tomorrow. The supremacy clause means that when the national government and the states conflict, the national government is supreme. So tomorrow, when you're looking at your assessment and you see the supremacy clause, you might want to match it up with the definition that includes the word supreme. When the national government and the states conflict, the national government is supreme. So tomorrow on your multiple choice assessment, there's a really straightforward constitutional clause matching section. and no tricks, these are the constitutional clauses that you will see. And we're going to go over them throughout our discussion. All right, the Equal Protection Clause has come up in our conversations throughout the year. We are going to spend so much more time talking about the Equal Protection Clause next week. The Equal Protection Clause is instrumental in our conversation about civil rights. So we've talked about it before. We will fully explore the Equal Protection Clause next week. The Equal Protection Clause basically means that we should be treated without unconstitutional differences under the law. The Equal Protection Clause has come up in our conversation when we looked at Baker v. Carr, Shaw v. Reno. Baker v. Carr said that malapportionment is a violation of your equal protection rights. Shaw v. Reno says that racial gerrymandering is a violation of your equal protection rights. So for tomorrow, a broad understanding of the Equal Protection Clause is perfect. And then next week, we'll get into the nitty-gritty of the Equal Protection Clause. The Due Process Clause, that came up a lot for us this chapter because many of our due process rights are considered civil liberties. Due process means that the government should not be able to take away your life, liberty, and property without following the proper judicial procedures. And we spent a lot of this chapter talking about those judicial procedures. Speedy public trial, the right to an attorney, protection from unlawful searches and seizures. These are all examples of due process rights. These next 3 bullet points all stem from the First Amendment. The Establishment Clause and the Free Exercise Clause are religious freedom protections found in the First Amendment. The Establishment Clause says, Congress shall pass no law respecting an establishment of religion. And we spent a lot of time talking about how that statement is highly interpretable, but how the authors of that statement very intentionally picked that wording. The Establishment Clause is often interpreted as a wall of separation between church and state, and most of the time that explanation is good enough. It is a little bit more nuanced and complicated than that in reality. For example, tax dollars cannot go towards purchasing Bibles for the local Catholic school. Tax dollars can go to providing busing to the local Catholic school. School-sanctioned prayer has been deemed unconstitutional, at least since 1947, based on the Establishment Clause. However, there is prayer on the floor of Congress. Our money says, in God we trust, we pledge allegiance to the flag under God, so it isn't as clear-cut as a wall of separation between church and state. Violations of the Establishment Clause are determined using the Lemon Test, which is based on a Supreme Court case that is not one of our required cases. One of our required cases that does deal with the Establishment Clause is Engel v. Vitale, which said that school-sanctioned prayer is a violation of the Establishment Clause. The Free Exercise Clause is also in the First Amendment. It's also dealing with religious freedoms. It basically means that you should be able to participate in your religion as your religion calls you to do. And while that seems very straightforward, it gets a little bit trickier in practice. What if your religion calls you to do something that is otherwise illegal? What if your religion calls you to do something that violates somebody else's civil liberties? And we did hash out some of these scenarios throughout this chapter. Members of the Santeria religion being told that they could not humanely sacrifice animals. People of the Amish faith wanting to keep their kids home from school after the 8th grade. These are all free exercise conundrums. Continuing with our conversation of the First Amendment, let's go back over our freedom of expression stuff. Our freedom of expression rights are protected by the First Amendment. And the current precedent regarding freedom of expression stems from our required court case, Schenck v. United States, and then it was kind of updated by a court case, Brandenburg v. Ohio, which not a required case, but important to understanding the current precedent. Schenck v. United States, as we said earlier, established the clear and present danger test. If your speech creates clear and present danger, then it can be punishable. And then the Brandenburg case added to the precedent the term imminent, or not the word imminent. Clear and present imminent danger can be punishable. Whenever the courts are writing opinions regarding freedom of expression and what is not creating a clear and present imminent danger, they will take into account what is commonly referred to through this phrase as time, place, and manner. So I think that was part of our conversation back when we originally learned this, but I do not think I specifically use that language, and so I want to make sure I'm doing that right now. When determining if something creates clear and present imminent danger, the courts are going to take into account time, place, and manner. And you brought up a really great example of this yesterday. You absolutely have the constitutional protection to protest. Is protesting by shutting down a highway overpass protected speech? Perhaps not, because of the time, place, and manner. Is using your body to block a highway creating clear and present imminent danger based on the time, place, and manner in which you are protesting? Probably. That precedent is used to gauge potential prosecution because, for the most part, we try to avoid what is called prior restraint. We would much rather a person be allowed to say something, maybe face punishment for it after the fact, than to have a definitive list of things that people can and can't say. A person's not allowed to yell fire in a crowded place. But short of those few exceptions, we very much try to avoid prior restraint. Symbolic speech is an action that conveys a political message. So it's not something that you say, it's not something that you write, but it is an action that conveys a political message. Symbolic speech is protected by the First Amendment. A person is allowed to burn a flag as a form of symbolic speech. The Tinker children were allowed to wear black armbands to school as a form of symbolic speech. But any action or every action cannot be justified and cannot be prevented from being prosecuted based on the justification of symbolic speech. So for example, you are allowed to burn a flag as a form of symbolic speech. You are not allowed to burn your draft card. You can't punch someone in the face and then claim that you were trying to send a political message. And in turn, you should not be prosecuted for that. No. So symbolic speech is protected by the First Amendment, but every action cannot be justified by describing it as symbolic speech. Libel and slander, those are false statements that injure a person's reputation. Libel's when you write it down, slander's when you say it out loud. The courts have been more open to restrictions regarding libel and slander, or punishments regarding libel and slander. Same thing with obscenity. Things that have been deemed obscene are more open to government restrictions. The definition of obscenity is something that lacks redeeming value beyond its appeal to one's sexual or violent interests based on contemporary community standards. So would the average person in this community, in this context, feel like this is obscene? And that's how they gauge whether or not something is obscenity. So what would be considered obscenity in downtown Beaver is probably very different from what would be considered obscenity in downtown Los Angeles at 12 o'clock at night. Okay. Questions from this first column. Anything repeated, anything explained a different way, another example needed. If there's ever anything in class, and this goes for every day, not just review days, where you feel like you couldn't give a basic explanation of that concept to a friend of your same grade level or someone at home, then we need to get together to remedy that. We need an understanding of these concepts so that we feel comfortable explaining them to others. That's the level of understanding I want you to have. And that's a good way of checking yourself too. Like, it's one thing to write down the definition and think you have the definition memorized, but challenge yourself, even just internally in your head. Like, could I explain this to another person? And if not, let's fix it. Okay, let's get to our second column here. Ex post facto, bill of attainder, habeas corpus. Those are all protections that can be found in the original Constitution. So these are things that are within the 7 articles of the Constitution. An ex post facto law, or protection from an ex post facto law, means that if something is legal when you do it, if that action is later made illegal, you cannot be punished for having done it prior. So if you do something on a Monday and then a law is passed making that thing illegal on a Thursday, you can't go back and be punished for having done it prior to the passage of that law. A bill of attainder would be a law declaring a person guilty of a crime. And we are protected from bills of attainder by the Constitution. It is the judicial branch's job to determine guilt or innocence. It is not the legislative branch's job to make that determination. So the Constitution says that Congress cannot pass laws that would declare a person or a group of people guilty of a crime. And then our habeas corpus rights means that if the government is going to take away our freedom, then we need to be made aware of our charges, and we need to be able to plead our guilt or innocence to those charges. So the government can't take us and put us in a cell and throw away the key. It never explained to us why we're there. It never officially pressed charges. It never gave us the opportunity to plead our innocence to those charges. So those are all protections within the Constitution as it left the convention. Procedural due process is just a fancy way of saying due process in action. So being given a lawyer, making sure that evidence is collected lawfully, ensuring that you have a public trial, that's procedural due process. So due process in action is procedural due process. Warrant and probable cause, that's not going to show up on tomorrow's assessment, nor am I going to ask you specifics about lawfully arresting someone or even lawfully searching someone. All of those nitty-gritty hypothetical scenarios that we got into the other day, I'm not going to ask you to break down any similar scenarios tomorrow. These real specific what-if scenarios. That's not happening on tomorrow's exam. So super quickly, there's search warrants and there's arrest warrants. A search warrant gives permission to search, and arrest warrant gives permission to arrest. In both of those instances, a police officer has to convince a judge that they have probable cause to search or probable cause to arrest. And the standard of probable cause is more than mere suspicion. So that is clearly up to the discretion of a judge. What reaches that threshold, what is more than mere suspicion, is going to be up to the discretion of a judge. In the interest of time, I was going to get your take on the exclusionary rule, but again, I want to make sure I have time to pass stuff back. So the exclusionary rule says that unlawfully gathered evidence cannot be used against us in a court of law. The exclusionary rule, that precedent was established by Mapp v. Ohio. And the exclusionary rule ends up applying to our Fourth Amendment protections from unlawful searches and seizures, and also our Fifth Amendment protections from self-incrimination. And we saw that through the court case Miranda v. Arizona. So the exclusionary rule says unlawfully gathered evidence cannot be used against us. There is something known as the good faith exception. And the good faith exception says if the error in gathering evidence is sufficiently minor, then that evidence can be used. And sufficiently minor would mean your rights weren't violated in that error. So someone put the wrong date on a form, or someone forgot to sign it, something like that might subject something to the good faith exception. A grand jury is not going to be on our test tomorrow. We didn't talk about it. I've never seen it come up even on an AP test, but it's part of the AP Gov curriculum, so here's a definition. A grand jury is when a jury of your peers gets to decide if charges are going to be pressed, rather than individual government prosecutors or judges getting to decide if charges are going to be pressed. So we're used to a jury determining guilt or innocence. A grand jury is used to determine if charges should even be pressed. Double jeopardy means you can't be charged for the same crime twice. Your Miranda rights, you have the right to remain silent. Anything you say can and will be used against you. That's a Fifth Amendment protection. You have the right to an attorney. If you can't afford one, one will be provided to you. That's a Sixth Amendment protection. Bail is money you pay to get out of jail while you're awaiting trial. Okay. Prior content is fair game on assessments. Let me give you a couple of hints for tomorrow. If you are asked a question about what a legislature could do, and I'm using the term legislature here on purpose to talk generally about a type of institution. Congress is one type of these institutions. Our state house and our state senate, that's considered a legislature. If you're asked a question, what can a legislature do? No matter which legislature it is, what's the best answer? Like, number one answer to what can a legislature do? What do legislatures do? I gave you some examples of legislatures too. What does the legislative branch and a legislature do? Congress is an example of a legislature. What do they do? I think you're overthinking it. What's Congress do? Edie? Makes laws, exactly. What does a legislature do? What could a legislature do? They could make a law. So that's something you might want to keep in mind when asked about legislatures. When asked about any branch of government, probably the first place your brain should go is, what's even the point of this branch of government? What could the executive branch do? Execute the laws. What could the judicial branch do? They could interpret the laws. What could the legislature do? Make the laws. Okay, so keep that in mind for tomorrow. Also for tomorrow, keep in mind how ideology impacts the courts. We haven't talked in depth about liberal and conservative yet, and that's okay. You don't need a definition of liberal or conservative for any of the test content tomorrow. But what we have talked about for sure is how ideology of judges, the ideology of the individual judges, impacts rulings. So even though we haven't had an in-depth conversation about the definition of different ideologies, we know that the judges bring with them different ideologies, and that's going to affect their rulings. And as part of that discussion of ideologies, we have already talked about being a strict constructionist or a believer in judicial restraint versus being a judicial activist. So hopefully that's all ringing a bell. Okay, questions?